Welcome to the Darkstream, Voxday, voxday.blogspot.com, and unauthorized.tv. Thanks for tuning in tonight. It's probably going to be a little bit on the short side because I forgot to charge up my battery. I have a spare battery, and of course that one is not charged up either. So we'll just go until the battery runs out. So 20 minutes or so. Let's save the super chats tonight because I don't think we're going to get to them. But I know a lot of you are curious about the announcement related to the Patreon situation and the judge's order denying the preliminary injunction. And so we're going to go ahead and talk about that. Now, but before I start, I just have to show something that I finally got, so I'm very pleased. The first Castalia Library book finally showed up here, and I have to say it's exceeded expectations. It's really well done, really beautiful. The quality's fantastic. Just this is like exactly what I imagined when we first started talking about Castalia Library. So it's really great to finally get my hands on one of them. Looking forward to getting my copy of Meditations. So anyhow, let's talk about the order. Now, this was not at all a surprise to the Legal Legion. In fact, I alluded to this several times on this stream and on the blog. And the reason is that the tentative ruling that was released is actually almost identical to the final ruling, and that's usually the case. I know a lot of the ankle biters and Owen haters were going on about, oh, this doesn't mean that, and this doesn't mean this, and they have literally no idea what they're talking about. And even now you're seeing some people trying to claim that, oh, it's just a preliminary injunction. It's not the whole lawsuit, et cetera, et cetera. And while that's technically true, it indicates that people are not paying attention. Those people are not paying attention to what the judge actually said. And that's the significant part. It's not so much the rejection of the injunction. We knew that was going to happen almost certainly. I mean, there's virtually no reason for an injunction in the first place. But the important thing is the reasoning. And so when you look at what the reasoning is, then you understand what is actually taking place, what's actually happening. So let me open this up, and then we'll go over this. And let's see here. Got to find the right package. And the thing that's been interesting about this process is that, as is often the case with people who are not truthful, what we're seeing is that new things are being opened up all the time, on a regular basis. And so, so here we go. Patreon seeks a preliminary injunction to enjoin defendants from continuing to pursue improper claims against Patreon and Jam's arbitration. And the judge says, Patreon's request for a preliminary injunction is denied for several reasons. First, Patreon fails to show it will suffer any irreparable injury or interim harm if an injunction does not issue. JAMS will determine these issues, affords Patreon an opportunity to object to its jurisdiction. If Patreon is correct that the claims are not arbitrable or outside the scope of the agreement, the arbitrators will rule in its favor. Merely having, and this is the key part, merely having to incur expense in order to participate in arbitration proceedings is not irreparable harm. So that was always obvious to us. That's why we never took the injunction aspect very seriously. This is where it gets a little bit more interesting. Second, Patreon fails to show a reasonable likelihood of prevailing on its claims. Even if Patreon were correct that the defendant's claims are not arbitrable, those issues are for the arbitrator, not the court, to decide. And then he cites a case, and then he also cites the JAMS Streamline rules, and then he points out that the arbitrator has the authority to determine jurisdiction and arbitrability issues as a preliminary matter. Indeed, Patreon asserts that a JAMS arbitrator has already ruled in its favor. And so, anyhow, then it says here, third, California courts rarely grant the extraordinarily relief Patreon seeks here, an injunction interfering with an ongoing contractual arbitration proceeding. Once a dispute is submitted to arbitration, and this is key here, in fact, I missed this the first time. Once a dispute is submitted to arbitration, the California Arbitration Act contemplates limited, if any, judicial involvement. So as soon as the arbitration is submitted, as soon as that demand is filed, the judicial system doesn't want to touch it. So, and then it quotes a decision from Briggs: "It is the job of the arbitrator, not the court, to resolve all questions needed to determine the controversy." That conclusion is especially true where, as here, the arbitration began without the need to seek a court order compelling arbitration. So, the judge here is just completely shooting down the entire concept of the courts interfering with arbitrations. Now that they added, this was what was new. This is what was added from the tentative ruling. But it's really funny if you speak judge at all. He takes a pretty good shot at their lawyers, because during the hearing, they showed up and presented what they said were 8 citations that were very important and addressed the issue, and would change everything. But you're not supposed to do that. You're not supposed to bring new stuff into the hearing. You're supposed to file it, and then everybody gets a chance to respond to it, read it, etc. So he says, to be sure, Patreon is correct that this principle is not an inflexible one. It's the general rule, but there can be exceptions made. This made me laugh. However, the cases Patreon cited for the first time at the hearing, that's the spanking right there, do not support its position. I mean, think about that. They didn't put the stuff in their filing. They bring it in and delay the judge's ruling and everything. And they cited 6 cases that don't support its position. And that's exactly what Randazza pointed out in his response to that. Just basically, look, these things don't support their position. And obviously the judge confirmed that. So that goes on for a bit. And then this is the other interesting part is, in addition to pointing out that the arbitrator, that the court doesn't have the authority to interfere with the arbitrator, he then goes on in the final paragraph to say that here Patreon, he refers to a case called Briggs again, and says, here Patreon is effectively seeking similar relief. Immediate review of JAM's interlocutory orders submitting the contested issues to the arbitrators for decision, rather than immediately granting Patreon's objections to arbitration or its alternative request to issue a blanket stay of the arbitration proceedings pending a ruling on Patreon's request for coordination of those arbitrations. This is stuff that was being fought out in the JAM system before the arbitrations actually went to the arbitrators. Under Briggs, the court lacks authority to review those administrative decisions. Accordingly, the court denies Patreon's request for a preliminary injunction. It is so ordered. So what's the significance of this? What does this mean? Well, what the judge is very clearly saying is that the court does not have the authority to interfere with the arbitrations once they're submitted. They don't interfere with the arbitrator, and they don't interfere with the JAMS process. So once it goes into arbitration, that's it. It doesn't go to court. It doesn't belong in court. And if Patreon wants to argue that it should be in court, then they have to argue that with JAMS. And of course, it's all pointless for them anyhow, because the whole reason that they're trying to drag it into court is because they're trying to get out of paying for the arbitrations. So what the judge has effectively done is said, your entire strategy isn't going to work. And that's why this is more significant than simply the fact that the injunction was denied. This is a very structurally significant decision, because he didn't pay any attention. He didn't even bother to look at what Randazzo was saying in defense of the 72 bears who are being sued. They have an excellent case. They have a very strong case. Patreon waived its right to bring a group action, and then they brought a group action. And that their case was hopeless from the start, which I said numerous times. But even I didn't expect that the judge was going to completely shut down their entire approach to trying to interfere with arbitration. And so, this victory in round 2 is actually very strongly indicative of a coming victory in round 3. I don't know what's going to happen next. I can't read the judge's mind, but he's pretty clearly signaled that the next step is probably going to be whatever is needed in order to throw the case out, because there's no reason now to continue with it. What's the point? He's already said the court does not have the authority here. The court does not have the authority to do what Patreon is asking us to do in the lawsuit, as well as the injunction. And so when you look at this, so what this means is that the focus of the disputes shifts back into arbitration, and of course then it's going to get even crazier, because Patreon is gambling everything on the idea that the non-Owen arbitrations are somehow dependent upon Owen's arbitration. But they're not. They're absolutely and clearly not. It doesn't matter if Owen decides to shut down his arbitration tomorrow. It doesn't matter if he loses. None of that matters, because that's not the basis for most of the claims being brought by the 72 bears, and it's not the basis of any of the claims by the people who are attacking the deceptive practices that Patreon is engaging in. Patreon has had 4 different terms of use in the last year. They've had 4 different terms of use in the last 7 months. And this is exactly the kind of behavior that some of these California laws are passed to stop. And so And on top of that, the JAMS has allowed the bears to, all the bears who are being sued are being allowed to amend their claims to bring in the lawsuit now. So, Patreon breached their contract when they sued the bears. And so now, in addition to their claims about deceptive practices, in addition to their claims about tortious interference, they've got claims against Patreon for breaching the contract and trying to impose legal costs on them and so forth. And so, but what's really interesting now, and what's probably going to be the most damaging thing to Patreon down the road, and I can tell you right now, they're probably going to have to change their terms of use again before the end of August. Just watch, because they've got this dispute resolution clause that's very interesting. Let me find this here. Okay, right here, dispute resolution. Now, this makes me laugh now. Okay, I'm going to add this to this page to the screen. Let's see how we do. Add source, window capture. There we go. Okay, so do you see where it says right there in the subtitle, dispute resolution? To summarize, if you have a problem, please talk to us. But you are limited in how you can resolve disputes. You waive your right to trial by jury and your right to participate in a class action proceeding. Oh, no, you don't. That's a lie. That is a flat out lie, and that is a flat out violation of California law, written law, and the decisions of the California Supreme Court. You do not waive your right to trial by jury. You cannot waive your right to trial by jury in California, not until you're actually in court and you fail to show up for it. Furthermore, and this is something that I posted on the blog the other day, so some of you may have heard this already, but furthermore, you cannot waive your right to a class action if you are a consumer who is in a contract of adhesion. And so this, which is exactly what everybody on Patreon is. So what was okay, this is in the California Supreme Court. They held as follows in Discover Bank. When the waiver is found in a consumer contract of adhesion, in a setting in which disputes between the contracting parties predictably involve small amounts of damages, and when it is alleged that the party with the superior bargaining power, which is Patreon, has carried out a scheme to deliberately cheat large numbers of consumers out of individually small numbers of money, such waivers are unconscionable under California law and should not be enforced. So what that means is that you can't waive that. You literally cannot waive your right to class action if you're a consumer in a contract of adhesion. Furthermore, you can't waive your right to a jury trial. And so what Patreon is putting in their, not just putting it in their contract, but putting it like in big letters in the subtitle, that is textbook deceptive practice. And every single user on Patreon, every single one of the 4 million users on Patreon have a strong claim for holding Patreon responsible for those deceptive practices. And so, what Patreon is doing is an absolute abuse of its consumers, an absolute abuse of its users, and there's no excuse for it, none whatsoever. And so, and all this stuff is new. All this stuff is stuff that, you know, we just figured out in the last couple of weeks. And so, you know, it's going to be interesting to see how this shakes out, because there's absolutely no doubt whatsoever of the outcome. There's absolutely no way that you can even hope to defend that. Troy wants to know if anyone's read eBay's new terms of service. Seriously? Of course I've read it. eBay is a little bit more clever in that they, despite being a California company, they try to conceal that, and they have a Delaware choice of law provision. However, that's very unlikely to hold up, especially if the consumer happens to be in California. You know, their ban on class action, all that sort of thing, is, you know, slightly more likely to hold up if the initial representative of the class was from outside of California. However, based on what I understand of the relevant the California approach to choice of law provisions, it's pretty clear that if you've got a California company and a California resident, there's almost no way that the court or the arbitrator is going to agree to stick by Delaware law. Kate Adams says, can Patreon drag this to appeals and stall? No. They could try to drag the eventual decision in the lawsuit to appeals, but see, that's not the issue. They're desperate to stop the arbitrations because they don't want to pay the arbitration costs. They're doing the same thing that Uber did. They're doing the same thing that DoorDash did. They're doing the same thing that Chipotle did. They're doing the same thing that all of these companies do, which is running to the court to try to save them from their own contract that they imposed on their users or that they imposed on their employees. And so, that's funny. Anthony says, if you search the internet for Jam's arbitration, you find Patreon's original terms of service all over the place. Yeah, Anthony's right. Patreon copy pasted themselves into a hole, and a lot of these tech companies have. I mean, you read their terms of use and you see all kinds of silly grammatical mistakes, typos, spelling mistakes, and it's very clear that there was never any serious legal analysis, never any serious strategy behind it, which of course is why their legal strategy has not only been ineffective, it's actually been completely disastrous, because everything that they do to try to defend themselves just makes their situation worse. It just makes them more vulnerable. It opens them up to more disputes, more attacks, etc., etc. And so, Andy Miller says, might Airbnb go down next? Well, I suppose it's possible. You know, I mean, frankly, I would really rather not have to deal with any of this crap. You know, these people are going to have to learn that they can't play thought police. They literally can't. They don't have the ability to. They might, you know, some clueless people in their trust and safety councils might think they have the ability to, but they don't. They just flat out don't. And so, you know, but what do you think? Are you guys tired of winning? Has it gotten old? Are you exhausted? Do you think it's just time to quit? I don't. I find it energizing. I find it exhilarating to have a new area to learn. I didn't know a single damn thing about California law, 9 months ago. I knew very, very little about it. But as a result of going through the whole Indiegogo thing, as a result of working with the Legal Legion, as a result of just reading a lot of case law and reading a lot of the California Code. I mean, how do you think that we knew about SB 707 before it even took effect? Because we stay up on this stuff. It's not just me. The whole Legion does this, and so it's just once you decide to embrace the conflict, that doesn't mean looking for conflict. Conflict in this day and age, conflict is gonna find you. It's absolutely going to find you. And so, it's just when it finds you, the key is to prepare yourself for it and do it right. People ask me all the time, this happened to me. Can I do something about this? Can I do something about that? Well, sometimes you can and sometimes you can't. To think that, we're smart and we know about the legal system. No, that's a huge mistake. You can't. That doesn't mean you can do anything. So, Unofficial Bear says, I'm 10 minutes behind. We get to amend it to include the lawsuit now. Well, Jams has said that you have to ask the arbitrator, and then the arbitrator will decide. But I think the chances of them saying no is pretty much zero, since it's happened, and Patreon is responsible for the fact that you're just getting to this point. So anyhow, looks like the battery is dying, so I'm going to let you go. But have a good evening. Embrace the conflict. Enjoy the conflict. And for the 72 Bears, congratulations and enjoy the victory. And let's work towards the next one. I'm Voxday. This is the Darkstream.